Hi everyone. Now I'm planning to deliberate on the recent amendments that has taken place in limited liability partnership. You may be knowing that in the recent days the LLP registration has keep increasing. In fact, if you see that records of the Ministry of Corporate Affairs, it's almost 236. I remember the number. So that means that day has gone where originally it took almost a year to reach 5,000 number for registration of LLP. Now you see after the year it came into effect 2009, as you all aware, from 1/4/2009, matter of 11 years, and now the number has literally got increased, decent number got increased to 2,37,000, which I was referring. So now literally actually the government now only has thought that changes in LLP is required. The reason being the business community was started more using the benefits of the LLP, just like the benefit that they were using for the company. Now, having understood that the business community now started preferring the LLP, then ministry felt it that just like a Companies Act, they have to bring check and balances and also certain important compliances and requirements, and probably even certain things to reduce the burden to the stakeholder in terms of compliances. So every aspect is touched in recent amendments. If you see LLP Amendment Act, which notified in 13th August 2021, which comes into effect, which came into effect from 1st April 2022, it got certain provision. In fact, I thought the idea of this particular deliberation itself that now I know many of my friends who started the LLP, many of them keep asking things, many things they are not aware of it, because for so many years you see there was no changes or there was no amendment in the LLP Act. So what happened, whoever started the LLP, they were in the impression that the amendment is there. So now recently government so fast they introduced lot of amendments. Corporate entrepreneurs and business community, they would not have come across the recent amendments. So I thought if I deliberate for 5 or 10 minutes, at least it will be useful to you. Probably after that you can leisurely see that what is the compliances that require to be done. But my idea is to throw some important points only, what are the things that has got evolved and developed in the Limited Liability Act. In fact, I keep telling almost last 10 years after LLP Act came that the LLP is nothing but an hybrid system. It combines the both benefits of the partnership and the regulatory aspects of the company, or whether we can even directly say limited liability aspects of the company, and the liberty and the privilege of the partnership firm. Now that's the reason government was not too much focusing on LLP bringing so many regulations or so many rules to restrict the operation by the promoters of the LLP or partners of LLP. But now the number of LLP also got increased, and also the importance of the LLP has been felt by the business community and entrepreneur now. That's why this recent amendment has come. Now coming to the amendment, I have to say that now, if you see as of now, the LLP Act has got 81 sections. Okay, now after this amendment came into effect, it became 85 sections. If you have to see, to understand that almost nearly 7 sections got introduced, and 5 got substituted and 3 got removed. So this is how the number goes in the recent amendment that has taken place. So now after this amendment, the total number of the sections is going to rise from section 81 section to 85 section. So though it's a small piece of law, but see the numbers that have got registered today, 231. So now it is very important, and also now Ministry of Corporate Affairs started to treat the limited liability partnership at equal to the in a same plate, okay, almost equal to the company, because reason being it gets the protection of the company, it gets the legal recognition or legal sanctity, where we generally say body corporate, okay. So it's just like another body corporate. Generally before the LLP comes, there was only one body corporate, which is a company in India. Now, after the introduction of the limited liability partnership, now LLP is also recognized, given a legal recognition as a body corporate. So now, because of this, now business community also started understanding the importance of it, and ministry also started improving the law based on the requirements that are coming across in the country or the business community, whatever they need it. So to rise up to the occasion, the government felt it that these amendments are important and necessary to see that the LLP also is regulated or governed or streamlined, well, we can say at par with the company. That's why they brought certain amendments to the LLP. There's one amendment act, which is the Limited Liability Amendment Act, and there's a 2 amendment rule has come for limited liability. I'm not going to go in deep because my idea is to just give an input for 10 to 15 minutes maximum. It's important to know this all amendment has came into effect with effect from 1st April 2022. There's a concept which was already there in the Companies Act, which already got implemented in the Companies Act. Now got implemented with effect from 1st April 2022, which is called Decriminalization of Offences. What is the Decriminalization of Offences? Because we keep hearing that many of you, these things may be lingering in your mind, that what it is. Decriminalization, okay, that means there's no imprisonment at all. No, it's not like that. The ministry has identified few sections, the same thing what has done for the Companies Act. Same way, LLP Act also they identified and they introduced a provision under the LLP Act for adjudication of penalties. Now, the government is trying to decriminalize the offences that are committed, technical offences. It's not that some willful, default kind of thing. It's a technical error that has been committed. So, without any, intention, right? So, these are the offences. Government felt it that they have to address it, and they need not to take them into the prosecution and give the burden to the business community. So that's the reason the government, they introduced to the adjudication of penalty process under the Companies Act, which gave the power to the registrar of companies to adjudicate the penalties. Similar provision has been introduced under Limited Liability Partnership Act, whereby the registrar of LLP will be now authorized to initiate the process of adjudication of penalty. So now with that, the registrar of LLP should issue a show cause notice as to why penalty should not be levied. Then it should be a responsibility of the LLP to give sufficient records to the satisfaction of the registrar. If they are not able to provide and one more important thing is that they have to provide all these details and submit their documents through online only. Now, what happens in case of adjudication of penalties? See, let's try to understand what is decriminalization, then I'll quickly go to next one. Take for example, section 34 in LLP, where it talks about filing of declaration of solvency with the registrar of firms within 30 days after expiry of 6 months from the end of the financial year. Okay, so Form 8 we call it. Now, what happened earlier, the situation is that if the company does not file the declaration of solvency within the time of 30 days time, what happened? They end up with a penalty. But here, earlier there's a the power given to the registrar of companies, wherein they can initiate the criminal prosecution against the default in filing the records. Now, that's what the government trying to say, that decriminalization. The idea of decriminalization is nothing but earlier the registrar of firm in case of LLP, registrar of companies in case of Companies Act, they were empowered to initiate the prosecution in case of any delay in filing, not default in filing. So now the powers whatever given to the registrar of companies and registrar of firm, now government by this amendment they ensured that these powers are taken away of prosecution powers in case of delay in filing, and they gave a registrar of companies the adjudication power. So that means don't take them and give a rigmarole experience to the business community or partners to the LLP, and same in case of company, directors to the LLP. Don't try to see that make them heavy to feel to run a company or to run a LLP, and spending time with the prosecution and getting disqualified, and there are a lot of provisions in different enactment in our country where somebody gets convicted and they will be disqualified for various benefits under respective laws. So in order to see that for technical error, why this level the impact should be given to the promoters and to promote the business in our country, the government felt it now it's the right time to see that the process of adjudication is introduced only for the delay in filing. That means there's a technical error, oversight in filing the records on time, and there is no prejudice caused to anyone, or there is no overburden to anyone, no one interest getting affected by that, but it's only a oversight that with the oversight the company would have skipped or LLP would have skipped. So the government felt it need not to be prosecuted and they should not be overburdened with the prosecution exercise. So they diluted it. They gave a power today to the registrar of firms to make sure that in case of any delay in filing, they are given an authority to issue notice and adjudicate and levy penalties. In fact, in case of LLP, it is up to 1 lakh. In case of partners, it is up to 50 lakhs. So the same exercise is done various sections whereby they removed the word fine and changed it as a penalty to make sure, because the idea of removing the fine is nothing but as long as it is a fine, then it triggers a prosecution, and the prosecution can only be heard and the trial can happen only, the conviction can happen only in the criminal courts. So that's the reason they thought the word fine should be removed, and the respective amendment has also been brought in under the LLP Act as well as in Companies Act similar way. In fact, now both Companies Act and LLP are at par in adjudication almost, except few changes, few differences. So now if you see, as I was referring that to avoid the prosecution, the adjudication process has been introduced. Now the registrar of company or registrar of firms are empowered to adjudicate and levy penalty. Therefore now they are not empowered to initiate the prosecution process by filing a complaint with the magistrate court and make the directors or designated partners to go and appear before the court, just for the reason that they filed with the delay. Even see, just you if you can think through, if a LLP file accounts or declaration solvency, instead of filing within 30 days time, if a LLP files on 31st day or 32nd day, it is not that we can deem it as a willful, or they are trying to do some fraudulent thing, because it's not a matter of 1 day delay is not going to decide, or it's not going to tamper or damage or prejudice anyone's interest. That's how the government thought that delay should be only, it's like a kind of a warning by paying a penalty, that they should be relieved from that stress so that they can concentrate more on business. That is one aspect. And similar way, like decriminalization, if you see, there are, as I was referring, that there are some important 6 to 7 amendment has come. In fact, to take you through on compounding of offences. Earlier, if you see, there was only one line in the compounding of offences. Okay, hardly one line that offences will be compounded by regional director. But now, if you see, after the amendment, there's a separate definition has been brought in to see who is regional director. Why the definition is required now? Because now the appeal provision is given to the regional director. From adjudication, there's appeal that should go to the stakeholders given an authority or right to appeal before the regional director. So in order to make sure that the authority is different, they brought even definitions done. Now the situation is little different comparing to the Companies Act. Now, as I was referring, that decriminalization idea itself is what? To see that the prosecution is not done. Okay. Now, same way, if you see LLP, the prosecution powers also is taken away from ROC. That means the regional director should be given certain power to decide, because after regional director, of course, it is only a writ jurisdiction that LLP should proceed for, or the partners of the LLP can go for. That means adjudication. From adjudication, there is appeal to regional director. from regional director, there is no further appeal. In fact, it can be only questioned by invoking the writ jurisdiction under 226 of the Constitution. So this is how the entire method or system has been introduced by Ministry of Corporate Affairs. In fact, I was started telling about other amendments, that decriminalization, I was referring compounding of offences. In case of compounding of offences, the same thing which was there in the Companies Act, now in LLP. But the important difference that one should understand is that in LLP, comparing to the Companies Act, in LLP, only the fine alone can be compounded. But in case of company, it is not that only fine or imprisonment also can be compounded with the due consent of the court. Okay, that's what the section 441 of the Companies Act sounds. Whereas in case of LLP, only the fine alone can be compounded by the regional director. So that's a big difference. In fact, the same procedure and process that has been contemplated under section 441 of the Companies Act 2013, the same has been borrowed and almost similar has been incorporated in the limited liability partnership. Coming to the another concept called special court. In fact, earlier the concept of special court was there only in the provisions of Companies Act, section 434, I remember. So the same special court concept now has also been introduced under the LLP. The idea is that since the regular criminal courts, okay, they are overflowing with the regular criminal matters. So this corporate matter, which are sensitive matter and where the value is involved is more, the damage is more in terms of the value. So government felt it that, okay, let's have a special court for that. So that it will not go into the regular criminal matters, and the company matters alone will be given a specific focus. So this is the idea. The special court concept has been introduced even on the Companies Act. Same is introduced now in LLP Act also. Now, but one more clarification has come saying that the special court, till it is constituted for the purpose of LLP, the special court already constituted under Companies Act 2013 shall continue to be a special court under LLP. Here, the important thing here again is that even now the Ministry of Corporate Affairs, to my knowledge, the special court is not constituted separately. Okay, actually the existing magistrate court, they designated that court as a special court. Now earlier those courts used to hear the complaint that generally be filed by the Registrar of Companies. The same court now time being has been designated as a special court. So this is the important thing that amendment has come. Now one more this thing, they omitted one section that is nothing but the punishment. No, punishment in case of order of the Honorable NCLT is not complied with. In case the order of NCLT is not complied with, the LLP Act was providing a punishment. The section means under provisions of the Companies Act, which provides the LLP a status of High Court with respect to contempt. You know, there is a Contempt of Court Act is separately there. There is a separate enactment in our country where it gives a power to the any order of High Court or Supreme Court. Then there is a provision to punish a person. So same provision has been extended, same privilege has been now extended under the provision of 2013 Act. That same privilege was not given under 1956 Act. In fact, under earlier Act, the Company Law Board was not enclosed with the contempt power, whereas today the NCLT is enclosed with the contempt power under 2013. Now, there was a provision under LLP Act where it was saying if the order of NCLT is not complied with, then the person will be punishable. Whereas, since the NCLT already has got a contempt power in his hand, in his fold, then this particular provision is only a duplication. So they removed it. Okay. Now, what is the next amendment? Very important amendment is about fraud under section 30. Here, if you see section 30, here though government is talking about decriminalization, but decriminalization, as I was referring, that it's only for a technical delay in filing forms. Okay, filing forms with a bit delay or a little late, or it's only a technical kind of a error or omission that can be treated as not prejudicial to stakeholders. Okay, as long as it is filed. So now, but government is very clear to segregate fraud and technical omission and commission. Okay, error or omission or commission, what in filing I'm saying. We need not to extend that level. We can say delay in filing and delay in rendering the duties under the LLP Act. So the government is very clear. Fraud is different and delay in rendering some function or duties are different. So that whereas in case of fraud, if anything committed by LLP or designated partner, in fact the earlier the punishment period was 2 years, now it got extended to 5 years. So very important to note here alone. In fact, one should understand that now you must be knowing that there is section 468 of Criminal Procedure Code which talks about limitation of offences. That no offences can be tried with the court. In fact, it is penalty up to 6 months only it can be tried. If it is imprisonment up to 1 year, only it can be filed. Is imprisonment up to 3 years, only it can be filed. So if you see, the punishment for fraud under section 30 of LLP has been increased from 2 years to 5 years. Now the protection whatever we get under LLP means Criminal Procedure Code section 468 got lifted now. That means the promoters or the partners or the designated partners, now they are exposed to directly to the criminal prosecution beyond the limitation period. Earlier, imprisonment punishment was only up to 2 years. That means the action should be taken by the department within 2 years' time from the commission of offence. Now it is not so. The department have got a right to initiate action against the wrongdoers at any point of time without any limitation. So this is the very important aspects which I thought I can deliberate with respect to LLP. In fact, there are so many amendments also has come. Even rules also got amended to say that in case of the LLP undergoing CIRP process, instead of declaration of solvency to be signed by designated partner, it can be signed by, in case of CIRP, by RP of the who is appointed as a RP. In case of a liquidator, if it is a liquidation, by liquidator. So those respective amendment has come in case of section 34 declaration of solvency, 35 for annual return. The respective amendment has come enabling the IRP RP liquidator to sign the form if the company is under CRP or liquidation. Similar way, there are few amendments has come like a small company and startup company. See, small company, if you see the capital is up to 25 lakhs and the turnover is up to 40 lakhs. So I think earlier the same threshold was applicable for the audit, for mandatory audit of the LLP. The same threshold has been followed now to deem a LLP as a small LLP. Same way, there is a concept of startup LLP where, as you all know, that startup company, same way startup LLP, after the registration, once the LLP get registered with the DIPB by following the process and requirements, it gained the status, it reached the status of startup LLP. So now, what is the benefit of a small company and startup LLP? The benefit is that nothing but comparing to the normal LLP, whatever the penalty is levied, the half of the penalty only will be levied to the small and startup LLP. So this is the special privilege by way of an amendment the government really intended to, they brought already. Actually, they were intended earlier to bring. Now they brought it and it came into effect also. In fact, these amendments are really very important amendments in limited liability partnership, because earlier there was no amendment at all, but now these amendments really going to help. And same way, certain sections of Companies Act has also been notified to made applicable to LLP. In fact, the declaration of beneficial interest section 90, which was made applicable to the LLP now. Same way, section 64 disqualification of director, section 67 vacation of director of office and compounding provision, and as I was saying, other related provisions, all are whatever was there applicable to the company, the same got introduced and given effect and made applicable to LLP. So therefore now LLP, whether it's a LLP or company, now they are obligated to follow all those sections which are notified to them to, as if it is applicable to the company, the same is applicable to LLP And I think these sections are very important sections. One has to read, and then that itself can be deliberated for hours together, those sections. But there are few sections which has been notified to applicable to LLP also. My idea is not that to cover entire thing. It won't happen. Even whole day deliberation also may be required to cover entire thing. Just to give an idea, so that it will be an alert to you, and so that you can accordingly go and verify and see that you are running the LLP in compliance. See you all. Thanks for your patient hearing.